Hello, I'm Vladimir Bello, attorney and partner with Bricker & Eckler, LLP.
And I'm Lisa Eshelman, an attorney and commissioner with the Ohio Environmental Review Appeals Commission, and we are members of the 2011 Mock Trial Case Committee. This year, the Ohio Center for Law-Related Education presents to you Taylor Henlacks versus Dr. Dana Brody.
The 2011 competition offers a universal twist on the 14th Amendment's takings clause, often associated with eminent domain. The case analyzes an individual's rights to the body parts of a deceased family member. When an individual dies in a sudden car accident, the family consents to an autopsy to determine the cause of death. During the course of the autopsy, a section of the brain is removed and sent to pathology, where it is discovered that the brain cells are regenerative or immortal.
Sean Henlacks' family has filed a lawsuit against the county coroner, alleging that the coroner has violated the family's due process rights by sending the regenerative cells to a research lab instead of returning them to the body. The trial for the mock trial competition will focus only upon whether the coroner's actions constituted an impermissible taking of property without due process of law.
Taylor Henlacks is the plaintiff in this lawsuit. The plaintiff will argue that the coroner's actions deprive the plaintiff of a cognizable property right without due process of law. The family's position will focus on these arguments. First, there is a violation of the 14th Amendment and the Due Process Clause because case law establishes that the sibling of Sean Henlacks has a constitutionally protected property interest in the remains of the decedent, including Sean's body parts and brain tissue. Second, the coroner's acceptance of compensation for turning over Sean's unique brain cells was improper, regardless of the social value of that work.
The plaintiff will bring to the court two of the three following witnesses. Taylor Henlacks, the plaintiff, is the older sibling of Sean Henlacks, the decedent, and family spokesperson in the matter. Taylor will testify that Sean was not registered as an organ donor and that Sean's belief was that medical research could be done without removing body parts. Furthermore, Taylor will explain that during a family friend's funeral, he or she heard Sean say that one's body should be whole and intact for burial. Parker Reese, M.D., is a forensic pathologist who works at the Buckeye County Coroner's Office. Dr. Reese will describe how Dr. Dana Brody asked him or her to run tests on brain tissue samples from Sean Henlacks. Dr. Reese will explain how, during routine tests, he or she discovered that the cells surrounding Sean's cerebellum tumor were regenerative or immortal. Dr. Reese will also address an email he or she sent to Dr. Brody sharing the discovery, but expressing how it was unfortunate that no further research would be done because the family had not given consent beyond performing the autopsy. Finally, Dr. Riley Jones, a member of Buckeye Medical Center's Medical Ethics Committee, will explain that though there are numerous guiding principles for the committee, one of the most important is respect human life and the dignity of every individual, and, in that regard, a patient's body or body parts should be donated to research only if the decedent or the family chooses to do so. Dr. Jones will also emphasize that to financially benefit from the use of a patient's body part against the wishes of the family is against the best interest of the patient and his or her family, and it's unethical to do so.
The defense will argue that Dr. Brody's removal and retention of Sean Henlacks' brain as part of an official death investigation is not an unlawful taking, and there was no violation of plaintiff's due process rights. The coroner's position will focus on these arguments. First, there was no property interest in the body parts that were removed lawfully during an autopsy in the course of an official death investigation. Second, Dr. Brody followed the required coroner's process, and Sean's family consented to the removal of the body parts. And third, Dr. Brody removed the brain on behalf of law enforcement authorities as part of a lawful death investigation and was, therefore, a state actor protected by qualified immunity.
The defense will bring to the court two of the three following witnesses. Dr. Dana Brody, the defendant and Buckeye County Coroner, will explain how he or she followed office protocol and received consent from Sean's family before removing a section of his brain to determine the cause of death. Dr. Brody will go on to explain that the discovery of the regenerative brain cells was an unexpected, but that the finding could have significant implications for future treatment of neurological diseases. Dr. Brody will argue that neither the Code of Ethics nor standard protocol preclude him or her from sharing this discovery. Randy Kelly, a patient who was diagnosed with a neurological disorder, will explain the daily struggles that a patient with this disease goes through and to relay his or her support for Dr. Brody's interest in furthering research to cure this disease, which, at this time, has no treatment options. Finally, the defense may call Sydney Oxfordshire, a member of the Mount Henry Hospital Ethics Committee, who will explain that Dr. Brody followed the Universal Ethics Committee guidelines of professional conduct and engaged in activities that promoted advances in medicine and contributed to the greater good.
Your job is to present the strongest evidence and the best legal arguments that can be offered on one side or another in the hypothetical factual scenario provided in these case materials. The attorneys who have prepared the case materials have based this case upon actual court decisions, with an eye toward framing the facts of this case in a manner that is evenly balanced between the arguments of the plaintiffs and the defendant. You should not rely on any court decisions or other legal information beyond that provided to you in these materials.
The Ohio Center for Law-Related Education and the Case Committee for Taylor Henlacks versus Dr. Dana Brody hope you will find this case challenging and thought-provoking. It is our hope that this case will give you a greater understanding of the 14th Amendment to the United States Constitution.
It is also our hope that all who participate in the high school mock trial competition will have a great experience, and we want to take this opportunity to go over with you a few brief competition reminders. It is expected that advisors, coaches, and parents will at all times model civil behavior towards and respect for the court and members and supporters of the opposing team. Additionally, please remember that the competition coordinators and judges are volunteers who have taken time out of their schedules to participate in this program. Understand, as it is in authentic trial situations, that judges may demonstrate different degrees of preparedness and may make rulings at their discretion that the parties may not always agree or like. We urge the mock trial participants to be flexible and understanding throughout the competition process.
Best wishes and good luck.